welcome. We are going to discuss ethical issues about intellectual property. First things first, we will give a brief introduction on what is intellectual property. What is intellectual property? Intellectual property is also known as works of the mind. Some examples are books, pamphlets, articles and other writings. The first known use of the term intellectual property dates to 1769, when a piece published in the Monthly Review used the phrase. The first clear example of modern usage goes back as early as 1808, when it was used as a heading title in a collection of essays. The German equivalent was used with the founding of the North German Confederation, whose constitution granted legislative power over the protection of intellectual property to the Confederation. When the administrative secretariats established by the Paris Convention and the Berne Convention merged in 1893, they located in Berne, and also adopted the term intellectual property in their new combined title, the United International Bureau for the Protection of Intellectual Property. The organization subsequently relocated to Geneva in 1960, and was succeeded in 1967 with the establishment of the World Intellectual Property Organization by treaty as an agency of the United Nations. According to Lamley, it was only at this point that the term really began to be used in the United States, and it did not enter popular usage until passage of the Bayh-Dole Act in 1980. Until recently, the purpose of intellectual property law was to give as little protection possible in order to encourage innovation. Historically, therefore, they were granted only when they were necessary to encourage invention, limited in time and scope. What are the other things protected? Aside from books, pamphlets, articles and other writings, some of it are works of drawing, painting, architecture, sculpture, engraving and lithography or any other works of art. Is there any way to protect it from piracy? Yes, intellectual property rights given to persons over the creations of their minds. They usually give the creator an exclusive right over the use of his or her creation for a certain period of time. As for its protection, there is a law called copyright law, wherein it prohibits illegal redistribution of copyright materials without the consent of the creator. Looking at this figure, we can see that even in industrial companies, piracy is one also of the issues. Some of them are not aware about using unlicensed software, and who knows that maybe they do. Aside from that, looking at this graph shows that only a few companies have policies regarding the use of only licensed software in their company. These are the following: punishment and penalties. For first offense, imprisonment of 1 to 3 years or so and a fine ranging from 50,000 to 150,000. For second offense, imprisonment of 3 to 6 years or so and a fine from 150,000 to 500,000. For the third and succeeding offense, imprisonment of 6 to 9 years or so and a fine ranging from 500,000 to 1.5 million. The value of damaged property from the infringement determines the number of years in jail time. If you cannot afford to bail, then the bail is then converted into jail time, which could even increase your time in prison. Here are top 5 disputes regarding intellectual property. 1. Amazon's one-click patent. Amazon was granted a patent for one-click technology on September 28, 1999. Also known as one-click buying, the technology allows customers to make an online purchase in a single click without having to manually input billing and shipping information every time they purchase a product. Instead, one-click uses a billing address and credit card or other payment info that is kept on file in the user's account. There have been several patent disputes surrounding one-click technology, including a patent infringement lawsuit filed against Barnes & Noble in 1999, only a month after Amazon's patent was issued. Barnes & Noble offered a checkout option called Express Lane, which also enabled shoppers to make a purchase with one click. The lawsuit was settled in 2002, however, the terms were not disclosed. 2. Google trademark keywords. In April 2009, the Second U.S. Circuit Court of Appeals issued a ruling stating that Google must continue in a trademark infringement lawsuit brought on by Rescue.com. In the lawsuit, Google is accused of selling the trademark name, Rescacom, as a keyword to Rescacom's competitors. The keywords are used to deliver Google's sponsored search results, therefore allowing competitors to appear on the results page when a user searches for Rescacom. The lawsuit was originally filed in 2006 and dismissed by the lower courts. This isn't the first time Google has found itself in the same legal predicament. Both American Airlines and Geico have sued Google over selling their trademarks as keywords. Google's trademark policy has gone through several iterations as the company attempts to find a balance that protects trademarks, yet allows retailers to advertise the trademarked goods they sell. 3. The Da Vinci Code Case. In the famous Da Vinci Code court case of Michael Bagent and Richard Lee versus the Random House Group Limited, Bagent and Lee alleged that Dan Brown, author of the best-selling Da Vinci Code, infringed on the copyright of their non-fiction work, Holy Blood, Holy Grail. Because Brown had not copied the text of the earlier book, the claim was based on non-literal copying. Bagent and Lee asserted that Brown told the story in the same manner in which they had expressed historical facts in their book. The claimant's case was dismissed in 2006 with a judgment stating in part that there is no copyright infringement either by textual copying or non-textual copying of a substantial part of HBHG. 4. Napster. In one of the Internet's the most well-known intellectual property cases, the Recording Industry Association of America, RIA, sued Napster, a file-sharing site. Founded in 1999, Napster allowed users to share music files and thousands of people began downloading songs for free rather than buying CDs. However, Napster did not own the rights to the music that people were uploading to its servers, where the music was stored and ultimately shared. The rights were owned by the recording artists and recording studios. The RIA sued Napster and won, causing Napster to close its doors or its servers, as the case may be. Napster now operates as a fee-based music download site and pays licensing fees for the music it sells. 5. Bratz Dolls vs. Barbie. In 2008, Barbie was finally declared the winner in the long-running intellectual property rights battle between Mattel and Kenga Entertainment Inc., the makers of Barbie dolls and Bratz dolls, respectively. In the lawsuit, Mattel sued Kenga claiming that Kenga stole the concept and the name of the Bratz doll from them. Carter Bryant, designer of the Bratz doll, was an employee of Mattel, but also working as a consultant for Kenga when he designed the doll. A few years after Kenga began selling Bratz, Mattel sued both Bryant and Kenga alleging copyright infringement. Because Bryant was on the Mattel payroll when he created the doll, the Bratz name and design are considered trade secrets. The courts sided with Mattel and ordered Kenga to pay $100 million in damages. We interviewed 2 students about their thoughts in intellectual property. Here's how it went.
Of intellectual property rights.
Yes, it covers copyrights, patents, and trademarks.
As a future software developer and as an IT student, how do you feel about piracy?
For educational purposes, I think it is beneficial for me, though it kills the software industry.
Do you think that piracy could still be stopped?
I think no, because there are always people who want free software.
Alright, thank you very much.
Are you aware of intellectual property rights?
Aware ako sa intellectual property rights, pero hindi ko alam kung paano siya tumatakbo.
Then, as a future software developer, how do you think intellectual property rights protect you?
Tingin ko hindi lang din ako yung mapoprotektahan. Siyempre sa gawa ng software by groups. So, hindi lang ako yung mapoprotektahan, pati yung team tsaka yung ideas ng mga teamwork.
So, how do you feel about software piracy?
Software piracy, na madaming kumpanya nalulungit dahil sa software piracy. Pero madami rin tumatangkilik kasi mura.
So, do you buy or download pirated media?
Bumibili hindi kasi wala akong tiwala sa online payment. Pero da-download minsan.
Okay, thank you for your time.
Thank you for watching.